suppose I was reading about this case of State of West Bengal and Committee for Protection of Democratic Rights, which is reported in 2010, 3 SCC 571, which is at item number 25 of your list, in the list of cases given to you for preparation. This is a bench of 5 judges who decided this. Very interestingly, what had happened was certain people were attacked and an FIR was lodged in the West Bengal state. And since the progress of the investigation was not on the expected lines, a writ petition was filed by the Committee for Protection of Democratic Rights in the High Court, saying that this should be transferred to the CBI. Now, this was actually allowed by the High Court and the investigation was transferred to the CBI, which was challenged by special leave petition in the Supreme Court by the state of West Bengal. See, how does it come in this angle of, you say, judicial review or anything? Is that the point which is decided in this case, what is very important is that the question of separation of powers, federalism, because if a CBI is a centralized agency, if a state which is doing the investigation regarding commission of an offense inside the 4 corners of a state is doing that, if a CBI has to come in, there should be consent. CBI has been constituted under the Delhi Special Police Establishment Act. If the CBI will have to investigate of an offense, it will have to have the consent of the state, was the argument. The argument was, now it violates entry 80 of list 1 of the 7th schedule. And the arguments of the state said entry 2, list 2 of the 7th schedule is violated. So therefore, we had exclusive jurisdiction. The violation of entry 2 of list 2 has to be taken. Federalism is affected and there is a violation of the division of powers. But the Supreme Court said, when there is a violation of fundamental rights and when it is a case when CBI, of course, being an outsider, it is normally consent is required. But in a case where it is required, the High Court need not take the consent of the CBI for passing such an order of directing CBI investigation in extraordinary circumstances. So this is what the union government contended, that this cannot, they cannot be stopped from going and doing certain investigations in particular states. So the court says, though undoubtedly the Constitution exhibits supremacy of the Parliament over the state legislatures, yet principle of federal supremacy laid down in Article 246 cannot be resorted to unless there is an irreconcilable direct conflict between the entries in the union and state list. So therefore, there is no quarrel with the broad proposition under the Constitution. There is a clear demarcation of legislative powers between union and states. And finally, it is held that Article 21 protects the persons of their lives and personal liberties. And according to the procedure established by law, the said article has a broad, application, and therefore it has to be upheld. In that light, in the federal structure also, even assuming there is a distribution of power also, if it is, the answer finally given for this reference by the Supreme Court is that in exercise of powers under 226, the High Court can refer this investigation to CBI in a cognizable offense alleged to have been committed within the territory without the consent of that state. It will neither impinge upon the federal structure nor it violates the doctrine of separation of powers. So this is a very important and a landmark judgment on this issue. Even when you are talking about separation of powers in an indirect manner was asked also, this is one of the very landmark questions, case law. When we are going into the criminal law angle, there are 2 important cases. I think I would like to touch upon both of them. According to me, both are important.